Right, good afternoon everybody. We're just going to give it just one more minute because I think we're still waiting for a couple more people to join us and then we will get started. Okay, well, good afternoon and welcome to Birkett Long's first Wednesday webinar, which we've put together amidst the COVID-19 pandemic. The aim of our Wednesday webinars is to deal with and address some of the legal issues that you as individuals and businesses might be facing. So today's Wednesday webinar is a look at some of the employment and HR issues that we've been dealing with our clients. And I'm joined today as well by my colleague Tracey Dickens, who is partner and head of the corporate finance and business team. And you'll see a little bit more from Tracey in a little while. So if I can just find out where I move the slides forward. So there we go. My name is Julie Temple. I am the head of the employment team, the BLHR and employment team at Birkett Long. Today, as I say, we're going to be having a look at the employment and HR issues. I do have to give a word of warning because things are moving at quite a pace, as I'm sure many of you will appreciate. So everything that we are talking about, certainly in the context of the employment side of things, is correct as at yesterday. So I checked the guidance last night to make sure nothing had changed. But it is important as you are looking at issues in relation to COVID-19 and in relation to your staff, that you are checking the most up-to-date guidance from the government. The notes that you can access after the session do include some useful links there, so please do take a look. And before you are making any decisions, make sure that you are dealing with the most up-to-date guidance. So it's a bit tricky to move the slides forward, so apologies for that. So we have been in lockdown now since the 23rd of March. And as a consequence of that, businesses are finding themselves in a situation where you have got a number of different broad categories of employees within your business. You have got individuals who are perhaps, I say you may have individuals within your business who are working as they have done before from the workplace. You might have individuals within your business who are working from home. I'm an example, Tracey is another, but we have a number of our colleagues who are working across our offices, processing post and getting that out so that we can continue to provide a service to our clients. You might also have individuals who are social distancing or shielding because of personal circumstances with their health, or perhaps they are pregnant. You might also have staff who are on furlough or who are unwell. Also, I suspect there are a number of businesses out there, a good proportion, who have actually shut their doors and are not able to continue to function. And in those circumstances, you might have a core number of staff in the business that are doing things like payroll and processing urgent and things that need to sort of continue. All of those individuals may or may not be working with reduced or altered hours, and with or without reduced pay. And they all have their own different employment law issues in terms of, can you place people on furlough? Can you just place them on furlough at 80%? Can we reduce people's hours? Can we reduce people's pay, even without reducing hours? And we have been assisting all of our clients with issues around all of that, and I will touch on some of those points as we go through today. So just a sort of diagram here to help you differentiate and make your way through that maze in terms of deciding where employees might fall and within which categories. This particular diagram starts off with somebody, whether someone is well or unwell, then follows through to, are they able to work? Now that can be at the workplace or at home. We then over to, I think it's the left, there's a question as whether or not they are working their contracted hours or reduced hours, or if there is no work, and you've got the outcomes in the blue boxes around the outside. We've then also got individuals who are self-isolating and or social distancing, and I've realised I need to update this diagram because those who are social distancing now are entitled to statutory sick pay and may be entitled to contractual sick pay as well. And to add into that, we've also got emergency volunteer leave, which is an option for certain staff who've been certificated by particular authorities to take emergency volunteer leave during the COVID-19 crisis. I'm not going to say anything more about that, but the notes do include details around that, who's entitled to take it. A key point, though, to make there is that those who are on emergency volunteer leave, if they request it, you cannot refuse it. They are entitled to take it. So moving into the job retention scheme, a large portion of my and the team's advice over recent weeks has been around the job retention scheme and what is now called furlough. It's a name I'd not heard of prior to about 6 weeks ago, and it's something that I've now become very, very familiar with. So as you can see on the screen there, furlough is a scheme that the government have introduced and under which employers can claim 80% of their employees' wages up to £2,500 per month. The condition that attaches to that is that your staff, any member of staff on furlough, have to, well, I've moved this too far forward, just bear with me. There we go, sorry, it just went one too far forward. Any member of staff on furlough is not able to carry out any work at all for the employer or indeed any associated business. Now, the furlough scheme is open for employers who had a payroll scheme and they had returned information to HMRC on the RTI scheme and on or before the 19th of March. It also applies to employees who were on an employer's payroll and had been submitted via HMRC's RTI scheme on or before the same date, so the 19th of March. As I mentioned earlier, it is only open for employees who have been instructed to stay away from work, and they cannot carry out any work at all other than limited amounts of training. I'll touch on directors in a moment, and Tracey will come into the conversation at that point. Furlough is for a minimum period of 21 days. That can be longer, but if there is any break of work in between, then the next period of furlough has to be a period of 21 days as well. And the furlough has to arise by reason of circumstances relating to COVID-19. Now, I've been discussing with a number of clients what that precisely means, but ultimately, if there is a reduction in work, you're not getting as many quotes through, as many orders through, that type of thing, and it is broadly related to COVID-19, then I think the chances are that you would be able to claim in respect of those employees. During the furlough, whilst an individual is on furlough, those individuals remain employees, so they will continue to accrue holiday, they will continue to be entitled to contractual benefits unless you agree otherwise. Now, there's been some discussion around and some confusion, frankly, around when individuals or what individuals have to do to be placed onto furlough, and there's some clarification from the guide in the latest guidance, which simply says as long as it is confirmed in writing, that is sufficient. So the employers have to say to the individuals, you are going on to furlough, and excuse me, you will not be carrying out any work for us over the period of the furlough time. So as per the previous slide, furlough payment is 80% of the employee's salary, capped at £2,500. Now, that is plus, as you can see, associated employer national insurance contributions and pension contributions. It does not have to be topped up by the employer. The guidance has been very clear on this throughout, that if you are placing employees on furlough, you can agree with those employees that that is the only payment they will receive. The difficulty with that, of course, is that an employee is entitled to be paid. They, broadly speaking, have no right, strangely, to work, but they do have a right to pay, even if there is no work to be done. So if you are wanting to vary their pay and reduce their pay down to the grant that you receive under the furlough scheme, you will need the employee's agreement. And I would always advise that you confirm or write to the individual, set that out in writing, and that's confirmed by them in writing, and that you keep hold of that as a written evidence and documentation to refer to in the future. Now, as per the last point there, government has only last week, I think, clarified that holiday can be taken during furlough. It unfortunately wasn't clarified before the last round of bank holidays, but we have a bank holiday coming up on this Friday. So any employees on furlough who would not normally work on a bank holiday and whose bank holidays are normally included in their holiday entitlement will be considered to be on holiday on their bank on Friday and should be paid 100% of their pay. Now, if you are only paying them 80%, that means you will have to top it up to 100%. Otherwise, you're barring a number of different technicalities, you would be in breach of the working time regulations, and that is the same for any holiday that they might otherwise be taking. and I'll come on and I'll speak about that in a little bit more detail in a short moment. So just final couple of points for me for a moment. As I said earlier, furlough should be confirmed in writing. You don't necessarily need anything back from the employee, but it's always good practice too. And the guidance does say that any written documentation, the confirmation should be kept for 5 years. Now, the indication is that that is how long HMRC are anticipating they will be carrying out audits in relation to furlough claims. So I'm going to pass across to Tracey now, who's just going to have a chat with you about directors' obligations and furlough.
Thank you, Julie. So I'm going to briefly look at directors under the furlough scheme. So salaried office holders, which includes directors, that is directors paid via PAYE, are eligible to be furloughed under the coronavirus job retention scheme. But unlike employees, company directors are on furlough can carry out statutory duties, provided they do no more than would reasonably be judged necessary for that purpose. And the directive says work undertaken by a director of a company to fulfil a duty or other obligation arising by or under an Act of Parliament relating to the filing of company accounts or provision of other information relating to the administration of the director's company is not work for the purposes of furlough. This is a very narrow specification and definitely focuses on compliance related activities. Essentially, the statutory duties would be things necessary to maintain the daily upkeep of the business from a statutory basis, including legal filings and record keeping. And this includes the likes of preparing VAT returns, preparing annual accounts, and updating general records and statutory records. It might, however, also encompass health and safety, environmental and employment legislation. So careful consideration needs to be given to how far directors should stretch their work for the company to best avoid a rejection by HMRC of a claim under the retention scheme. Remember, the terminology is that directors can carry out statutory duties provided they don't do no more than would reasonably be judged necessary for that purpose. So stay away from duties that would more properly fall on you in your capacity as an employee. It might otherwise be necessary to furlough perhaps only some of the directors and keep others in post able to exercise all of their duties. Now, a sole director company could potentially furlough a director in relation to his or her employment duties, but would not be able to do so in relation to his or her statutory duties, as a company cannot operate without a director and all directors have ongoing statutory duties to the company. And as with many of these arrangements, there are still some difficult questions around. One is that one of the statutory duties that directors have is to promote the success of the company for the benefit of its members. And this has led the Institute of Directors to ask the government to clarify the extent to which a furloughed director can act to save their company, as arguably such acts would be in line with that particular statutory duty. There's no answer yet, and at this time the relaxation is very much related to compliance arrangements. So the best advice is make sure that's what you're doing and that you're only doing things reasonably judged necessary for that purpose. Back to you, Julie.
Thank you, Tracey. Okay, so I'm going to move on when I can find the little arrow and carry on and having a look at some of the issues that you as businesses are going to have been experiencing. Now, I appreciate that there are exceptions to every rule, but the vast majority of our clients are experiencing reduced work. Now, within the current context, how can you accommodate that? Well, as we've said, with illness, actually, you might find that you've got reduced work, but you've also got reduced numbers of staff who can actually carry out the work that you have. So you might find that you are needing to recruit temporary members of staff, and you might find that perhaps you're having to juggle individuals on furlough. Now, a difficulty with that, and I've been advising a client on this morning, is what happens if you place someone on furlough one of their colleagues goes sick and you need to bring them back, unfortunately that is likely to mean that you lose the ability to claim for the days they've already been on furlough, but you then place them back on furlough and try and get them within a 3-week window to deal with that. Home working, I think I read a stat earlier this morning, there's something like 53% of the population who are working from home now, which is a huge number over, and it almost happened overnight. You might be able to exercise a contractual right to lay off your employees, i.e. send them home without any work and not pay them. I would caution you against that, where furlough is now an alternative option. And certainly I think you can use the layoff or the short time working, which is where you have the ability, the contractual right to reduce working hours and reduce pay accordingly. I would always say now, whilst the furlough scheme remains operational, that you offer furlough as an option, and only if that is refused for whatever reason, you look to exercise your rights to lay off or short time working. I think if you go straight to layoff or short time working where furlough is available, the employees are likely to cry wolf, so to speak, and say that's a breach of contract. You are acting inappropriately and unreasonably as an employer, and you should be putting me on furlough. A number of employers are discussing and agreeing reduced working and reduced pay, even if you don't have the right within contracts to do either of those things. And one advantage of the current situation that we are in, and I'm sure many of you will have heard the expression, we're in the same storm, but we're all in different boats. Everyone has this storm and we are all dealing with it in different ways, both individually and as businesses. But the advantage of the storm being so widely experienced is actually employees are much more accepting of an employer coming to them and saying, I can't pay your wages this week. I'm going to have to defer it till next week. I'm going to have to defer it until we get the payment through on the furlough scheme. And I think you will find employees surprisingly receptive, but again, with exceptions to every rule. Other options include paid holiday, which you can force, as I've mentioned previously. Redundancy. I am advising a number of clients in relation to current redundancies and potential future redundancies, unfortunately, as they look to the future and start to plan for what a return to normal might look like. We've heard in the news different businesses taking different approaches and saying, okay, I can't pay you now, but I'll pay you in the future, or actually I'll pay you in stage payments in the future. Much less likely is the final one there, full pay whilst at home and not working. As I say, furlough became very quickly the go-to option for most. And in my experience, clients and businesses are able to agree that quite readily with their staff. So also we have got individuals who are unwell, unfortunately. Quite early on in this crisis, the government stepped in and agreed and indeed implemented legislation to say that individuals who are unwell with COVID-19 or self-isolating with symptoms could receive statutory sick pay, and that's from day one. And this is COVID-19 related absences, not sickness absences generally. SSP can be paid from day one. And as usual, we have a situation where employees can self-certify for the first 7 days, but thereafter they should be producing a fit note. Now, obviously the COVID-19 situation and lockdown means that it's not quite as convenient to nip to the GP. So there is the ability to get an isolation note now and they're available from the NHS website in particular circumstances. And the other thing to note in relation to statutory sick pay is that employers with less than 250 employees as at the 28th of February can reclaim up to 2 weeks statutory sick pay from the government. So there is support from that. The reason it's 2 weeks is because the self-isolation period where you are suffering from symptoms is 2 weeks, to see whether or not that sort of translates into anything more serious. So as we move on, I've briefly mentioned holiday a couple of times so far. We have a situation in this country where employees are entitled to 5.6 weeks as a minimum for their holiday entitlement. A little while ago, the government announced that, and indeed introduced legislation to say that 4 weeks of that entitlement, if it cannot be taken as a result of COVID-19, if it's not practical for it to be taken as a result of COVID-19, it can be carried forward for up to 2 holiday years. So it accrues in the current holiday year, it can be taken for up to, or in any of the following 2 holiday years. As I say, that's only where it cannot be taken, or it's not reasonably practicable, words that us lawyers like to argue over, to take it in the particular holiday year. And I do joke about that, but actually I am envisaging a large number of arguments over reasonable practicability and whether it relates to COVID-19. My view on it is it's more to do with key workers who we need working, rather than individuals who prefer not to take their holiday because we're in a situation of lockdown and they can't go away, they can't go out, they can't enjoy their holiday in perhaps the same way they might have liked. And I have a degree of sympathy with that, but equally as businesses, we have to have in mind the future and the return from lockdown, and the fact that actually if we return from lockdown and individuals start requesting holiday, that's going to make the recovery that much more difficult. So I'm certainly working with employers and encouraging them to manage holiday, which does in some instances include giving notice to employees, both at work and on furlough, to take holiday. Now, as I say, I have a degree of sympathy with both sides of the argument, but you do have that ability. And if you do have to give notice, the notice that you have to give, subject to any contractual variation to this, is twice the period of notice of the number of days you want them to take. So you want them to take a day, you have to give them 2 days notice. So that's something to bear in mind. And it's all around the flexibility. You can refuse holiday and you can request it to be taken, and that's during furlough and for employees working. I mentioned earlier the position in relation to bank holidays. If bank holidays are normally taken as holiday, unless you cancel them, they will be taken as holiday and it should be paid at 100%. And that's the case whether you're working or whether or not you're on furlough, and whether or not you may have agreed a reduced wage whilst working. There are some further details in the notes about all of these things, so please do grab a copy of them and have a read through. I'm perfectly happy to answer questions if, once you've read them and got them, there's any questions arising from that. Duty of care. I do just want to mention this because my experience is that businesses have kind of got through that we've got a crisis situation to manage. We've now got people who are working at home quite happily or working at work quite happily. We've got a fairly steady situation now, and businesses are starting to turn to the more practical elements. So in terms of thinking about home workers, you know, you might have to think about, okay, have they got a desk to work to work on? Are they working from on their sofas with laptops, whatever, on their laps? Again, I was reading some stats this morning. A survey apparently suggested that 5% of people working from home are working on their beds. Now, as an employer, you are responsible for the health and safety of your employees, and that is your employees wherever they may be, whether they're at work, whether they're at home, whether they're on furlough, whether they are unwell. So you need to be thinking about all of these sorts of things and what sort of equipment home workers have. Are you storing up problems around how their workstation is set up, potential back issues, shoulder issues, etc. So you need to be thinking about risk assessments. Now, communication as well is key, and making sure that you are up to date with government guidance, but not only that you're doing all of those things, but you're communicating what you're doing. So you're risk assessing, you're adjusting policies and procedures, you're giving equipment, you're giving personal protective equipment, you're putting in place arrangements for the future. Make sure your employees and your managers are aware of that. They will find a reassurance in communication around those issues. If you can show you're up to date with the latest guidance, they will think, okay, fine, they're on top of it. When I come to return to work, I know that they will be on top of it. They've been on top of it throughout. They will feel much more comfortable. Some obvious things around making sure contact information is up to date, but also thinking about the vulnerable groups. So the individuals who are pregnant, the individuals who have health issues. And as I say, the notes do deal with all of these points in a little bit more detail. One brief word around protecting the employment relationship. This is a challenge for all businesses and individuals alike, and I am confident, and it's rare that I will be certain about things. I am absolutely certain that there are some businesses out there who are seeing this as an opportunity to remove staff that perhaps they might not have wanted, and also making some less than sensible business decisions. I won't point the finger, but there's a certain very well-known celebrity who happens to be married to a former footballer, who's received some bad press recently around furlough, but ultimately our employees are the future. So whilst you might need to make some difficult decisions to cut costs, etc., you do have to think about how you deal with that with your employees, because ultimately if you annoy them, then they are less likely to do their best for you when they return. So I would urge you to just bear that in mind. My final bit is just in terms of the rush to return to normal and what we will be rushing to return to, and thinking about what great things have come out of the COVID-19 situation. Some of you may think these sorts of things are good, some of you may not, but I'm sure that there are good things that have come out of it, and I'm sure that there are less good things that have come out of it. So do take time to start to think about it. I know businesses are starting to look at it. Businesses are starting to think about restructure. They're starting to think about whether or not redundancies do need to be made. And of course, if you're talking about 20 or more, we've got a clock ticking in terms of when furlough ends. But equally, recruiting and flexible working. I would encourage you all, as having advised a number of employers over a good number of years, there has been a reluctance to embrace flexible working. And I think as we return to the new normal, I'm hopeful that businesses are going to see the advantage, environmental, individual, and for businesses, as a consequence of the flexibility that we have seen. And I would encourage you all to think about that perhaps in a much bigger picture than perhaps has been the case before. So please do have a think about it. And I think actually I've not moved on the slide. There we go. So yeah, just sort of how my head works there, the examples of flexibility, technology demand leading to restructures, redundancy, recruitment and flexible working. So I'm going to pass across now to Tracey. Jen, have you taken control, Jen, to pass across? Thank you.
Thank you very much. Thank you, Julie. And certainly I can bear witness to the fact that flexibility in the workforce has been a really positive thing at Burkitt Long. We've embraced it previously, and it's worked really well, and productivity has definitely seen an increase. So anyway, I'm supposed to be talking to you about board meetings and so on. So I'm going to look at some implications of isolation on company meetings. So private companies are probably used to calling board meetings on short notice and also holding them virtually, or certainly in a more flexible way. And the key, in whatever form it is held, is to ensure it's quorate and therefore effective. If problems arise with meeting the quorum due to directors being unwell or not having access to equipment for virtual meetings, then perhaps consider alternatives such as appointing alternate directors. But note, an alternate director may not be appointed unless the articles specifically provide for it, and model articles for private companies do not contain provisions for the appointment of alternate directors. So express provisions will need to be included in the articles to be able to use alternate directors. Alternatives to meetings might be using written resolutions, where people might not have access to video conferencing facilities. They might still have access to emails, and you might be able to send resolutions around to achieve votes and so on matters that need resolving. And you might consider delegation to a committee. So if you've got less numbers of directors available, perhaps through furlough, you might at least get the core directors together, or a quorum of directors, and then delegate matters to a smaller committee of people who are available. But again, delegation to a committee requires provisions in the company's articles authorising the nature and extent of delegation. Here, though, model articles do contain a general authority, but you would need to check that that hasn't actually been removed. And note, certain acts still require a specific power to delegate to be included in the articles and will not be covered by the general power. So, for example, power to determine directors' fees and remuneration requires a specific authority in the articles. If you look at AGMs, just need to bear in mind, do your articles require your company to hold an AGM, perhaps within a certain time frame? If so, you may need to arrange for the shareholders to resolve to adjust the articles to remove that requirement, or if it's not going to be possible to hold it. And now private companies aren't required to hold AGMs, but there are some companies who choose to require the company to hold an AGM every year. So that the point is, check your articles and check what the position is, so you can address it. Looking at minutes, it's a requirement of the Companies Act 2006 that minutes of directors' meetings should be taken, and failure to comply is actually an offence. With difficult and unusual decisions needing to be made by the directors, it's important to keep a good record of the proceedings, the decisions made and how you reach those decisions, so you can evidence the matters you considered in reaching those decisions. And that evidence is going to be quite important to help you evidence your compliance with your statutory duties and show the types of things you've considered in coming to the conclusions and decisions that you have. Turning now to GDPR. So just briefly, again, some considerations at this time. You've all been focused, as Julie said, on how you're going to work during lockdown, and now you've perhaps got that under control. It's time to consider some of the implications of that new way of working. And the pandemic may have resulted in businesses and organisations collecting and processing new types of information about individuals, including health information, such as whether employees are displaying symptoms of the virus, the health status of other members of their household, perhaps COVID test results, and possibly tracing where they visited. And much of this will be personal data and some of it is sensitive, now special category data, which needs to be used in compliance with data protection laws. So businesses do therefore need to ensure they understand what personal data is required in connection with the purpose for which it is collected, since we're all obliged to collect only as much personal data as is necessary for that purpose. And that's the principle of data minimisation. So it would be a good idea to review what you're collecting to ensure you're only collecting what's necessary and appropriate. And you also need to be certain as to where the data is located and that it's secure and that we have a legal basis for processing it. Essentially, we should not just abandon our duties under GDPR and should at an appropriate time allocate time to reviewing our business in the light of altered data processing arrangements to ensure we manage the highest priority risks. So we should consider conducting a data protection impact assessment for any new working arrangements that involve processing personal data. We need to consider where personal data is being shared and ensure relevant contracts are in place if this involves sharing with third parties. Now, obviously, you might be sharing data with the same people that you've already got contracts in place, so you should be covered, but it's worth considering, has that actually widened and are you now dealing with new third parties where arrangements need to be put in place? And we should ensure employees are notified of any necessary changes to data processing policies necessary for dealing with the pandemic, such as sharing personal data for contact tracing or insurance purposes. And we need to check we have legitimate grounds for processing the data, and if that requires consent, that we've obtained that consent. But note, when dealing with employee data, we would usually be expecting to have another legal basis to rely on rather than consent, because consent can be withdrawn. In the UK, employers will be able to rely on the lawful basis of carrying out obligations in the field of employment or social protection law. However, if you were perhaps collecting data in relation to perhaps visitors coming to your premises, and hopefully that will be possible in the very near future, you might rely on protection of vital interests, as visitors' health could impact your duty to your employees. But it's about identifying what is your basis for processing the data and making sure you have that covered. So also high priority on the assessment will be data security and ensuring employees are aware of their obligations to keep personal data secure in the home working environment. And this might involve restricting use of non-secure platforms, ensuring data is not sent outside of your business systems to less secure home systems, not printing things remotely because they can end up left on printers in empty buildings for long periods of time that then come into view of people who shouldn't be seeing the information, or there's a risk of it, being bundled up and lost somewhere when it shouldn't be. So no remote printing, not removing hard copies of files or data from the office without adequate safeguards, being aware of increased vulnerabilities to cybercrime because the usual procedures have had to change for home working. So consider what alternative safeguards might be required. And are your employees using their own equipment to work from home? Again, what safeguards are needed to protect your data? What antivirus software or encryption solutions can you apply? And then I'm going to look at the government's position on GDPR at this time. So if you're in the health sector, the Secretary of State has issued 4 notices under certain patient information regulations requiring certain health organisations to process information related to the pandemic, and this is to ensure they can share the data needed to be able to respond to the virus. However, the government guidance confirms that data controllers are still required to comply with relevant and appropriate data protection standards to ensure within reason that they operate within statutory and regulatory boundaries. And the UK Information Commissioner's Office has also issued guidance on compliance with UK data protection laws in the context of COVID-19. And the ICO acknowledges that organisations may find it difficult to adhere to usual data protection compliance standards as resources are diverted away from data protection compliance. So while the ICO appears to be sympathetic to this challenge and suggests that enforcement action may not be taken against organisations failing to comply with their obligations, it's a welcome concession, but I really recommend that businesses are not complacent, because the flexibility may be construed very narrowly And if it's clear that once the dust has settled, you haven't turned your mind to data protection issues, when perhaps it would have been reasonable to expect you to do so, then you risk, you will still risk data protection enforcement. And of course, if you've been complying with data protection requirements, then you'll be in a good place to further review, check and adjust your compliance anyway. So hopefully it will just be a small review and adjustment just to make sure you're staying on top. And if you're recording these things in board minutes, please do minute your decisions. Julie, back to you.
Thank you, Tracey. Oh, I've got an echo there. I've still got an echo. Is that better? That is better. Right, I don't quite know what happened there. Okay, so thank you, Tracey. We're just in the home straight now. So before we go into questions, you'll see a link on the slide there. I think Sarah's going to post the link into the Q&A to the survey. So if we do appreciate your feedback in relation to all of our events. So if you have any comments, positive, negative, suggestions for future topics you'd like us to cover, then please do fill in the feedback there. We'd love to hear what you have to say. As I mentioned at the start, this is the first of our Wednesday webinars, and as you can see on the screen there, we've got a number of different topics coming up. Next week's Wednesday webinar is looking at, excuse the noise in the background, rent, repairs and other concerns for business tenants during lockdown. My children are having a funny 5 minutes. And then there's a whole host of other topics there, so please do have a look. I'm sure we'll be posting future events there as well, and Jenny will no doubt be cursing me for having said that. Thank you, Alex. Just had a delivery of tea and a biscuit. Okay, so that's that. We've now got questions, if we may. If there are any.
There are some, Julie, yes. And I will start with you, Julie. There's been a couple of questions regarding bank holiday. One of the questions is, if furlough staff have to be paid 100% when it's a bank holiday, should the company backdate that to include the April Easter holiday if the staff were on furlough at that time?
Yes, is the short answer to that. Although in one sense, if employees haven't raised it, you might take the view, one of my children has just appeared, off you go. Thank you, it's been wished a good presentation. If they haven't raised it, then you might take a view that you won't, but my view is, going back to my comment earlier about protecting the future relationship, I would say backdate it, give the top-up pay, or at least acknowledge that you have to, and that might be paid perhaps when things are a little bit easier.
Okay, and if they've had a pay variation, should that pay be what they've been changed to, or their full 100%?
It should be their normal pay, so it should be the 100% rather than the pay variation. The reason being, holiday should be paid at the normal rate of pay. Now there are arguments that the normal rate of pay is now the varied pay, but if I'm quite happy to sort of talk to people about it, but generally speaking, it will be the normal pay.
Thank you. Next question for Julia again is, what are our options if an employer refuses to come back to the office, but we have all social distancing measures in place? What if government guidance remains as stay at home if we can work from home, but the employer wants us to go into the office?
Okay, so the second part of that is, if employees, whilst the guidance remains as it is, if employees can work from home, then that is what they should be doing. If the job is not capable of being done at home for whatever reason, I mean, we are starting to see an increasing number of these queries. The starting point is looking at the arrangements for health and safety and reassuring the individuals that you have done and everything is in place that is possible to protect them. But if they still refuse, technically speaking, then you can take the approach of saying, we have work available, your health and safety is protected because we have all of these health and safety provisions in place. You are refusing to work and you will not be paid whilst you continue to refuse. Now, I appreciate that's a difficult conversation, and you need to have a good long discussion with the employees and try your best to reassure them before you get to that point. The other point to make there is that employees who are refusing and they're concerned about their health and safety might also be protected against detriment and dismissal. So I would very strongly advise speaking to your advisors before you take a step of saying, we are not going to pay you. But that is theoretically the end point.
Thank you. Again for you, Julie. A couple of people have been asking about redundancy. One of the questions being redundancy at the end of furlough, starting with structured decisions. Are we able to give notice at the end of furlough, i.e. the 30th of June, but what if it gets postponed again?
Well, on redundancy, you can make redundancies during furlough, and notice can run alongside furlough or at the same time, which technically means you get an 80% contribution from the government towards notice. There are some technical provisions as to whether notice pay has to be paid in full.
Come down for tea.
Okay, sweetie, I'm just finishing off. Or if it can be paid at the reduced rate, but you can do either. You can give notice during furlough, or you can wait until the end. If it's extended, I mean, I personally feel, and this is my personal view rather than anything else, that we will see some variation on furlough coming out in the not too distant future, which will allow employees to return to work, but there will still be some sort of contribution from the government. That's my feeling, but whether that will happen, I don't know.
Thank you. Again, Julie, can we pay holiday rather than allowing employees to carry leave over?
No, you have to pay. Employees should not be paid for holiday unless they're being taken. If it's not being taken, then you have the option to roll it over. But it shouldn't be paid other than any contractual over and above. It shouldn't be paid otherwise, except on termination.
Okay, I have a question for Tracey. About directors on furlough, given the risk that having no operational involvement makes it hard for them to defend a disqualification action, should there be a later insolvency? Sorry, Tracey, you're on mute. Sorry.
A small technicality there. I was trying to say the statutory duties, as I mentioned, don't cease because somebody's on furlough. So you might a furlough director is still able to implement their statutory duties and are actually obliged to do so. So that's not a reason to not be making those decisions. And one of the duties is to consider the impact on creditors of the company, in particular if the business is at risk of going into insolvency. So I think the message should very strongly be, you need to keep complying with your statutory duties, and that's got to continue to be taken into consideration.
Thank you. Next question for Julie again. If an employee is classed as vulnerable and has to self-isolate for 12 weeks, are they to be put on sick pay or to be furloughed?
You can do either. They are entitled to be paid statutory sick pay. but the furlough guidance has clarified that those individuals can also be furloughed. And if we go back to my comment about protecting the employment relationship, I would say, well, I suppose it depends really on whether there's a contractual sick pay scheme that might be more beneficial than furlough. But if it's SSP only, then I would say you are far best to agree with the individual to furlough them, and then they get the furlough pay, rather than them getting statutory sick pay, which is, you know, £90 odd per week.
Thank you. Another question for you, Julie. If a member of staff was put on furlough for 3 weeks, so the letter which went with the agreement says 3 weeks, do you have to send another letter to extend it?
You don't have to, but I would say in the interests of good employee relations and making sure you've got a document trail, it would be sensible for you to send it. It might be best to send it on the basis that it's open-ended rather than it being to be reviewed at another date. But I would certainly say, if not confirmed in writing, certainly speak to them. I'm sure you will have already done that, but definitely document it if it's practical.
Thank you.
But not necessary.
Another question for you, Julie. Apprentices, the training provider has gone out of business. What responsibility do we have to continue the apprenticeship?
I would need to have a look at the apprenticeship agreement, but my instinct would be that there is an obligation to try and find an alternative provider, and then only if you can't would you be able to terminate it. But I'd need to have a look.
Okay. Another question for you, Julie. Is the employer legally obliged to reimburse employees who have purchased equipment to work from home?
It will depend on what it is. For example, I've bought various bits and pieces just to make my life easier, but I will not be going back to Birkett Long to ask them to reimburse me. It will depend on what it is. If it's, for example, a keyboard, then I would say arguably maybe, because you would be wanting to protect their health and safety. Equally, there is an argument around sort of offsetting the fact that perhaps employees aren't travelling to work anymore, so therefore they're saving, as against anything that they might have purchased. Again, I think it's one of those, it depends on what it is and what it's been purchased for.
Thank you. And the last question I have, which is again for you, Julie. Can we carry out formal capability meetings such as ill health or disciplinary via Teams or phone dial-in, and issue out outcomes via email rather than hard copy, as we are all working from home?
Yes is the answer to that. I have seen an email today actually that ACAS have published a guidance about carrying out disciplinaries during the current situation, which I haven't had a chance to read yet. But subject to reading that and ACAS taking a different view, which I wouldn't necessarily take as gospel because they have been known to be wrong, that yes, you can. But we are seeing an increasing trend of employees not wanting to participate in that way, for reasons that, well, various reasons, I'm sure. But the simple answer is yes, you can continue with those processes and procedures, but I would do it as far as you possibly can, as realistically as you can. So over this type of forum, have a team meeting or a Zoom meeting or whatever else type of meeting is available online. And if they still object to that, you can offer them the alternative of submitting comments, etc., in writing. Now, as an employee, I would much prefer to be on the phone or in a video call than submitting something in writing, because you can obviously answer questions and so on and so forth.
Thank you, Julie.
All right, so I think that brings us to an end of the first Wednesday webinar. I'm hoping for a few nods from my colleagues. Yes, I've got a nod. Okay, well, it remains for me then to say thank you. I'm sure Tracey will say the same if she can unmute herself. Yes, I've got a thumbs up from Tracey as well. So thank you very much for joining us. I hope you found it informative. Please do download a copy of the notes, and do feel free. Tracey and my details are up there on the slides there for you to get in contact with us. We're very happy to spend a few minutes with you, answer any quick questions that we might that you might have. We are working and we are available, and we are most definitely here to support our clients, new or existing. So please do get in touch. Please do look out for the future webinars and do sign up if any of those are of interest. So thank you very much for your time. I wish you a good rest of the evening. I think it's Wednesday. So thank you very much.